Kouri Richins' trial for the murder of her husband Eric is just weeks away, and the former children's book author is making a bold new claim against prosecutors as the trial nears, and it has to do with witnesses. I'll explain the whole thing. I'm Angenette Levy, and this is Crime Fix. There's a reason that Morgan & Morgan is America's largest personal injury law firm. It's because the firm fights for its clients and wins a lot in court. The firm has more than 1,000 lawyers that have recovered $25 billion from more than 500,000 clients. In the last few months, a client in Florida got $12 million when the insurance company offered just $350,000. In PA, another client won $26 million. That was 40 times the insurer's offer. Morgan & Morgan makes it really easy to fight for what you deserve. You can even start a claim from your phone. So if you are ever injured, you can start a claim at forthepeople.com/crimefix. Click the link below or scan that QR code that you see right there on your screen. Kouri Richins is accused of poisoning her husband, Eric. Eric Richins died in March of 2022 of a fentanyl overdose. Now, Kouri has pleaded not guilty to murdering Eric, along with an attempted murder charge related to an allegation that she tried to kill him earlier in 2022. And now, just ahead of her trial, Kouri Richins is accusing prosecutors and two of their investigators of witness intimidation involving two of their own witnesses. Now, I'll get into the specific allegations that Kouri is making and the text messages to go along with them in a bit. But first, a quick refresher on how we got to this point. Prosecutors say that Kouri spiked Eric's Moscow Mule with fentanyl that night in March of 2022 after trying to unsuccessfully poison him a month earlier on Valentine's Day by poisoning his sandwich. The case has captured the attention of people across the country. From the outside looking in, Kouri seemed like a successful realtor, a loving wife and doting mother to 3 young sons. But prosecutors say appearances can be deceiving. They say Kouri was up to her eyeballs in debt, with hard money loans for her business stacking up. They will tell the jury that Kouri asked her housekeeper to help her get drugs and that she used those drugs to poison Eric because she believed she would have access to Eric's life insurance policy and inherit his money. But that didn't happen, according to prosecutors, because Eric Richins ensured that Kouri wouldn't inherit his money or benefit from his life insurance policy if he died. Kouri has vowed to fight the charges, telling a Dateline producer in 2024, "This is war." Jury selection in Kouri's case is scheduled to begin on February 10th, and testimony in the trial could go between 5 and 7 weeks. And now, a little more than 2 weeks before jury selection is set to begin, Kouri Richins and her defense team are demanding prosecutors and their investigators hand over any and all communications they've had with witnesses, including calls, voicemails, text, and digital messages. Kouri Richins' team is making this demand because they're accusing 2 investigators for the prosecution of intimidating their own witnesses. And Kouri's lawyers say they have text messages to back up their claim. In a motion to compel, Kouri's lawyers write, last week, the defense team received notice from one of the state's witnesses, W1, that she was being harassed by an investigator working with the prosecution and inquiring whether there was anything we could do to protect her from them. The witness forwarded text she received from lead detective Jeff O'Driscoll, attached here too as Exhibit A. As the court can see from the attached text, the witness made it clear she did not want to be prepped by the state to testify and asked them to send her any of their questions in writing. Detective O'Driscoll responded by threatening to get a warrant for her arrest and to bring a pole for her dog if she did not come in for an interview. He also threatened W1 with jailing her. This is blatant witness intimidation, the attorneys wrote. Now, the witness is only identified as W1. No name is given. So let's take a look at Exhibit A. It's a text message that was referenced between W1 and Detective O'Driscoll. O'Driscoll wrote, "At your request, I really need to set up a meeting with you to court prep you with the prosecutors. You are welcome to do it over Zoom, FaceTime, whatever. We just need to get you set up. Please respond." Witness 1 responded, "You can ask me whatever you'd like to ask me over text message. I do not want to be prepped. I do not want to be paid. Whatever you'd like to speak to me about, you can send it through messages, not through county sheriffs. You guys are some blood-sucking, unfeeling people. So go ahead. What? The message below appears to be another part of another message from O'Driscoll that states, please respond to our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog. Witness 1 responds, I don't need to be prepped. Give me the time and date and I will appear. O'Driscoll responded, it's on your subpoena. Witness 1 responds, is there more an exact date or do I need to be there February 23rd through March 26th? O'Driscoll responded, we could have discussed that if you ever replied, but since you don't want to, you can just plan on showing up every day at 8 o'clock. Witness 1 responded, I would like it over text message so that I have exactly what you say in writing. Crazy. So Witness 1 contacted Kouri Richins' defense team, and despite Witness 1 being a prosecution witness, the tone of this message makes me wonder whether this witness is really more sympathetic to Kouri Richins. Defense attorney Kathy Nestor says she met with the lead prosecutor about the text between Witness 1 and O'Driscoll, and he did not believe O'Driscoll had done anything wrong. And there's a second witness the defense claims the state intimidated. This allegation involves a second investigator for the prosecution. So to discuss these allegations, I want to bring in Jeremy Deus. He is a defense attorney based in Utah. So he's very familiar with everything that goes on out there and with the statutes and the laws in the state of Utah. Jeremy, thank you so much for joining me. I'd like your thoughts, just, immediately your gut reaction on this motion to compel and the allegations of witness intimidation being made by Kouri Richins' defense team.
So my gut reaction is that it's not going to amount to kind of a criminal charge of witness tampering or witness intimidation or anything like that under Utah's statute. I don't think it'll go that far. I do think that a lot of what they're doing is overreach as far as the prosecutor's office, how they're handling it. But I don't think it'll be criminal, and really knee-jerk reaction, these two witnesses, if they feel like they're being harassed, if they feel like there's tampering going on, anything like that, I think they should get attorneys themselves to help walk them through this process.
That's interesting that you mentioned that, because a lot of times witnesses will retain counsel to kind of be the go-between with them and the prosecutor's office. And one of the witnesses, I want to read the text exchange that we're going to put up on the screen, witness 2. And this witness even says they have immunity, which you would think that maybe if this person has immunity, they would already have an attorney handling all of this for them. This is from this Detective Travis to the witness, or the back and forth between them. Hey, Travis, I've already given a statement and I'm not interested in talking about this any further. And the detective responds, I understand your position and acknowledge that you have previously provided a statement. However, I want to clarify that the immunity granted by the prosecution remains conditional upon continued cooperation. Declining to participate further may place that immunity at risk. Accordingly, your cooperation is still required. Please give me a day and time you can stop by the sheriff's office so I can discuss the issues at hand. And then the witness responds, honestly, Travis, everything I have to say, I've already spoken and provided you with the document for everything you asked. I have been 100% forthright and cooperative, and I will continue in all caps to be cooperative. This interview happened nearly 2 years ago, and rather than take the time out of my busy day, what further questions do you have? I also want to add that when we met, I was told by everyone in the room that I had done nothing wrong. Even so, I will continue to be cooperative. So this person's been granted immunity. So that makes me think that there was a risk that this person could have faced criminal charges.
Well, I mean, that's the implication, right? And if there's been a grant of immunity, there should be some form of an immunity letter. Anytime, and we handle these sorts of things with criminal defense attorneys sometimes when we have clients who turn state witnesses who have the possibility of criminal punishment, there's generally always a letter that names certain things that are required as far as the agreement goes. And full cooperation is always a part of it. So, to what extent they have an actual immunity letter, I mean, we just don't know, right? We
Mhm.
haven't been shown anything. I don't know if defense has been provided a copy of it. They certainly should have in the discovery process. But if there was a grant of immunity and a letter provided, there will be a provision in there that says this applies so long as you remain cooperative.
What is your take on this back and forth? I mean, do you as a defense attorney feel this is coercive at all, or intimidating, or because I'm looking at the witness tampering statute, and it makes it sound like, if you were, you said earlier, I don't think this is going to amount to a witness tampering charge, and if I look at the statute, it makes it sound like, it's illegal to induce a witness to testify falsely, withhold testimony, elude the legal process, things of that nature. So that's what legally witness tampering is. But do you find that this is, does this sound coercive to you? Like if you don't do this, you could get charged criminally.
I think coercive is probably a little bit strong. It's absolutely overreach in my mind to
Mm.
me. It's whatever representative it is for the state, the prosecutor's office, kind of going above and beyond what I think they should. The only thing that the witness is required to do is show up to testify at trial, right? The
Mm-hmm.
interesting thing here is, and I know some of the prosecutors on this team. I used to work with a couple of them
Mm.
in a past life when I was a former prosecutor. One of them, and it's kind of interesting here, was a prosecutor on the John Swallow case. And for those who aren't familiar with the John Swallow case, they actually had an issue with a witness who said he was going to be out of town. So they went through the process of getting a material witness warrant to basically take him into custody, which will probably come into play when we talk about the other witness in this case here, where they're threatening to kind of take them to jail, right? And I know we haven't gotten to that point, but kind of the threshold question with all of this when I talk about overreach is the requirement is showing up to testify. And again, these prosecutors know when they're talking to witnesses, they have these conversations with witnesses all the time, witnesses who are cooperative and going in and being prepped. They'll ask questions like, do I have to talk to the defense team if they reach out to me? And generally speaking, most of the prosecutors that I've worked with in the past and that I know will say, you don't have to. So again, when we're talking about overreach, it should be the same thing where it's, look, we want you to come in and prep with us. If you don't want to come in and prep with us, you don't have to. Just let us know that you're willing to show up and respond to the subpoena, which both of these witnesses have done.
And I thought it was pretty common for prosecutors, defense attorneys to want to prep their witnesses. And when I say prep, I don't mean tell them what to say, but to just, go over their statement, ask them questions. You told the detectives this, you told them that, whatever. And it's not like you're inducing them to say something that they didn't say or to shade their testimony, or at least that's not how it's supposed to go. But if somebody doesn't want to be prepped, should that be the end of the conversation? Like, I told you what I told you. Like, just tell me when you want me to be there and I'll show up and you can ask me the questions. I mean, is that okay? And should it just stop there?
Well, I mean, if you really want it, and yes, you're correct. Whether it's a defense attorney talking about their witness, whether it's a prosecutor talking about their witnesses, you absolutely, it's best practice to try to prep them. If they don't have the ability to, I don't see anything wrong with saying, well, we would really like to sit down and talk to you, just because trial is a whole different thing than what you've experienced in the past with
Mm.
sitting down with us. And we want to prepare you for that. We want to make sure that you have the materials that you need to kind of familiarize yourself with what you've said in the past and kind of prepare you with those sort of things. There's nothing wrong with having that additional conversation. But when you're talking about starting to kind of, well, if you don't come in and talk to us, we're going to pull your immunity letter, pull our immunity agreement, or we're going to come in and we're going to arrest you. That's where it kind of goes over the top. And it feels a little bit like here with the messages that I've read and familiarized myself with,
Hmm.
that they did go over the top. Though again, I don't think it stretches into the realm of criminal conduct.
I want to go back to O'Driscoll's messages, and I before I introduced you, I went through some of O'Driscoll's messages where he's saying, if I have to come back, I'm going to bring the pole for your dog and all of this stuff. And this witness, we don't know these witnesses, but this witness went to the defense apparently and said,
Mhm.
"Can you help me out?" This makes me think this person is reluctant to testify against Kouri Richins. Maybe this is somebody who's very friendly with her, a friend. I don't know that. It's just something I'm maybe reading into this, and I could be wrong. I could be right. I don't know, but O'Driscoll's kind of rough, and I don't know the prior interaction between these two, but he
Mhm.
seems a little rough for somebody who's reluctant.
Right.
And I don't know this person, but this person says, "I don't need to be prepped. Give me the time and date, and I will appear. It's on your subpoena. Is there a more exact date?" And he basically said, "Well, basically we could have discussed that if you would have met with us." And then there's another set of text messages where, again, he seems a little rough. This person says, "I would like it over text messages, so I have exactly what you say in writing." And he says, "You are legally obligated to show up on the dates and times on your subpoena." So he's basically saying you can show up for like 5 to 7 weeks every day at 8 a.m. and sit there, essentially,
Right.
is what he's saying. He says, "I know you think you have nothing to do with this case, but here are the facts. You are a material witness in a murder case. You have received a subpoena to appear in the court as a witness. If you fail to do so, the judge will issue a warrant for your arrest. You will then sit in a holding cell until you are needed to testify. So make your life easier and answer our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog." I mean, that's a little rough,
Right.
isn't it?
It's absolutely rough. You're exactly right. And this is again comes down to an issue. What he's talking about there, where he's talking about getting a warrant and arresting you to ensure you come, is assuming that they're not going to show up to trial, right? If you
Right.
look at the requirements for a material witness warrant under the Utah rules of criminal procedure, I mean, there's got to be some implication that they're not going to show up to trial. These witnesses are not saying they're not going to show up to trial. They're both saying, "Hey, I'll come and show up to trial. I just don't want to have to come down and sit down and talk to you." That's all they're saying.
Yeah.
So they're not even going to meet that threshold question, right? So I mean, yes, that is very threatening and obviously the most concerning, but again, when it comes down to the intimidation of a witness statute, I don't think it meets the criminal level. Overreach, absolutely. Speaking too strongly, absolutely. Um, should these people, this witness in particular, get an attorney? I think so,
Yeah.
just to create that buffer and to say, I guess, call them out on the fact that they're saying we're going to come in and we're going to have a subpoena and we're going to throw you in jail to make sure that you come in and testify. No, I'm going to come in and testify, and that's really where it ends.
I doing what I do, if somebody sent that to me, I'd probably chuckle. And when I chuckled at this, I'm not laughing. I
Mm-hmm.
don't think it's funny. I think it's a bit absurd. But I would probably chuckle and be like, because I know I can call a lawyer and be like, "Take care of this." But if I'm
Mm-hmm.
just a regular person who doesn't deal with this type of thing and travel in these circles, I'd be like, "Holy smokes. Like, you're going to throw me in jail? Like, what
Right.
WTH and WT
Right.
other stuff." So, like, I don't get it. And then Kathy Nestor in her motion says she talks to the prosecutor, and the prosecutor's like, "Yeah, I didn't do anything wrong." So,
Mm-hmm.
so what's going on there? Like, is this really the way you want to treat witnesses? I get it's a big case and it's a big deal and it's important to you, and maybe you've been dealing with some frustrations along the way, but it's really like these are human beings.
Absolutely. And that's one of the hard things I think about being an attorney in general is kind of the I don't mean ignorance in a bad way. It just is what it is, right? I mean, people like you said that don't run in some of these circles and don't understand the normal process and how things work. Um, these can come off incredibly threatening and incredibly scary. And it should be something where everybody understands. I mean, even if it's to the start of a case and a police officer reaches out to you and just as a detective and says, hey, I want to talk to you. Talk to an attorney first and break it down and make sure that you feel comfortable with going into those meetings. And where there's been this amount of pressure, yes, people absolutely should.
At the heart of this is a motion to compel, where Kouri Richins' team wants all the communications that investigators have had with witnesses, et cetera. Is the judge going to grant that?
That's going to be interesting to see. The state, I imagine, is going to try to argue that a lot of it is kind of their own prep and is not subject to disclosure. The defense feels like they have an argument to come in and say, we've had these issues. We want to know what they're saying to other witnesses and what other witnesses are saying to them. It'll be interesting to see what Judge Mrazek decides to do. But if I were a betting person, I would say he'll probably say they don't have to turn over all the communication. There may be some limited communication, but I don't know if he'll order them to disclose all of it.
Interesting. This has certainly been interesting to read. I guess I just don't read a lot of text messages between cops and witnesses. But I would advise that this is maybe not how you handle it. Sometimes you get more flies with honey. That's the old saying. Again, we don't have any background on prior communications, but
right.
It's certainly really something to read this. Do you think that, just looking at this case, Jeremy, and you are in Utah, how closely are people in Utah watching this, in your opinion?
I think when you're talking about Provo, Summit County in general, that whole area, Camas, Heber, I think you're going to get a lot of attention. As far as what it looks like statewide, the further out you get, the more kind of national it gets, right? The crime junkies who watch and listen to all of the podcasts out there, right? They're absolutely paying attention to it. From a local perspective, when I kind of talk to people about it, I mean, if you're either into it or you're not.
Right.
And I think that the further out you get, I mean, probably more in Salt Lake, it probably matches a little bit more closely to the national level.
Well, we will certainly be watching. Jeremy Deus, thank you so much for joining me. I appreciate it.
You betcha. Thanks for having me on.
At the time of this recording, the state has not responded to this motion to compel or the allegations that investigators were intimidating state's witnesses. That will happen probably later this week, and a hearing on this motion will be held next week. That's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.